Hi, everyone. Good evening. My name is Bella Ribb. I am the executive director of the Constitutional Law Center here at Stanford. And tonight, it is my privilege to introduce our constitutional conversation on the Fourth Amendment and immigration raids. Today, we have two very special Stanford Law School guests. We have first Professor Orin Kerr. He's a professor of law at Stanford and a senior fellow at the Hoover Institution. He teaches and writes on criminal law and criminal procedure, often focusing on the impact of new technologies, and he is widely considered a leading authority on the Fourth Amendment. We also have Duncan Hosie, a fellow at the Stanford Constitutional Law Center. He previously served as the Stephen Poland Fellow in Constitutional Law and History at the Brennan Center for Justice at NYU Law School. He also practiced law at the ACLU Ruth Bader Ginsburg Liberty Center and a leading appellate practice. With that, I'll turn it over to Duncan to give us a sense of the structure of the event, and we can kick off this very exciting and timely discussion. Thank you.
Thank you, everybody, for coming. I'm Duncan. It's an honor to be here with Orin, who is the nation's preeminent Fourth Amendment expert. Orin and I see this case probably a little bit differently, and that's great. Universities need to be places where people have civil dialogue about topics they disagree, particularly those that deal with the most consequential questions of public life, and the immigration raids in this case fall into that area. Briefly, our event's going to have three parts. It's going to begin with each of us speaking for about 10 minutes, presenting our interpretation of the shadow docket order and its consequences. In the second part, for about 10 minutes, Orin and I will go back and forth, talking briefly about some areas. And then for the final 20 minutes, we're going to open up to the floor and hear from you to share your comments and questions. And with that, I'm going to give it over to Orin for his presentation.
Cool. All right, turn this on. Hopefully that's working. All right, so I wanted to talk about the context of how the Fourth Amendment applies to immigration raids, and then talk about this case, because I think you really can't understand what this case is about without knowing what the law is before you get to this case. The opinion, quote unquote, that we're talking about is actually like one line. It's like a paragraph, like we vacate the order. So this is really in the context of an ongoing case. An injunction was entered, a preliminary injunction. This is about what's going to happen over the course of litigation, an order about what kinds of immigration enforcement can occur, and the Supreme Court lifted that without explanation. We then have a concurring opinion by Justice Kavanaugh solely on his own behalf, explaining why he voted in favor of lifting the injunction. And then we have a dissent by three justices as to why they voted against lifting the injunction. There's no like majority opinion to analyze. There's no ruling to analyze. It's a interim docket, emergency docket, shadow docket, whatever you call it, order. And so to understand what happened, I think the best way of understanding this is to go through the law and try to understand what is going on with the law, compare the state of the law to the injunction that the trial court entered, which then the Supreme Court lifted. And let's take a look at some of the details and try to understand what the court did and where the law is after this ruling. All right, so the first thing to know is that there are three kinds of categories of police individual interactions that are relevant here: consensual encounters, temporary detentions, and arrests. A consensual encounter, the Supreme Court says, is when the police just walk up to somebody and start asking them questions. It could be pretty intimidating questions. It could be questions, for example, as to somebody's immigration status. Are you lawfully in the United States? Can I see some ID? All sorts of questions which somebody might find really intimidating and might understandably find quite intimidating. And the Supreme Court has said that is not a search or seizure under the Fourth Amendment. There's no regulation of that at all. And nothing in the Supreme Court's new shadow docket ruling questions that. This includes, there was an immigration case going back 40 years now, the INS versus Delgado case, where immigration officers were posted at the exits to a building where there were a large number of people working inside, and they questioned each individual person, do you have a legal right to be here, asked for immigration documents. Held no seizure here, so no cause is required. The next category, and the one that becomes relevant in the current decision, is a temporary detention. This is a stop and frisk temporary detention for which reasonable suspicion is required. So this is like the officers have told the person to stop. They've made an order, hey, you stay here. Or if the person's in a car, they have pulled them over. But it's very temporary. So under this standard, it can be, I think of maybe like 20 minutes or something like that, 10, 20 minutes. It's not a permanent arrest. It's not a taking somebody away. It's sort of an on-the-scene temporary stop. And the Supreme Court has said that that can be done with reasonable suspicion, a standard lower than probable cause. Last category is a full arrest. Probable cause is needed for an arrest. So that would be either a long-term detention or moving them, taking them down to a police station or taking them to a detention center. That's something that is an arrest that requires probable cause. What's the role of race in this question? Of course, is a salient issue with the new ruling. The key case here is a 1975 ruling, Brignoni-Ponce, in which the government, sort of similar immigration enforcement case in which the government took the view, believe it or not, they took the view that basically we can stop anyone who looks of Mexican ancestry. And that's it. That's the only fact we need. Basically, anyone who appears to be of Mexican ancestry can be stopped. And the Supreme Court says the standard for an immigration stop is reasonable suspicion. And we don't question that immigration enforcement is important. But the mere fact, the single fact of apparent Mexican ancestry is relevant to reasonable suspicion for a detention, but is not itself enough to create reasonable suspicion. So that's Justice Powell's view, joined by Justices Brennan, Marshall, Stewart, and Rehnquist. Majority ruling of the court that race is relevant, but race alone is not enough to generate reasonable suspicion. Critical to understand, I think, that in assessing what is enough reasonable suspicion to engage in an immigration detention or any detention, the standard is objective, not subjective. So what that means is the issue is, was there sufficient evidence as judged kind of objectively, not what was the officer thinking? So this is maybe kind of counterintuitive. Like you could have an officer who's hoping to violate the Constitution, hoping they don't have cause, but they actually have enough cause, and then the legal answer is that's totally fine. The hope, the wish to violate the Constitution is not actually a constitutional violation. What matters is, was there enough cause? And so what the Judge Sutton, I think, made this nicely in a decision last year. We don't focus on the subjective intent of whether the officer's trying to violate the Constitution. Trying not to violate the Constitution doesn't mean that they didn't, and trying to doesn't mean that they did. We look at what the evidence was, not what the officer was trying to do. Last important point here I want to flag is that over the last 30 or 40 years, the Supreme Court has really cut back on what the remedies are for Fourth Amendment violations in ways that are particularly important in the immigration setting because immigration law is federal, and the remedies are often going to not be in criminal cases, but in removal proceedings. So the first thing you need to know is that there's basically no longer a civil remedy for lawsuits against federal agents for constitutional violations. I think this is a mistake. I think there's a historical remedy here. It would have been a trespass or detention action, unlawful imprisonment, civil tort action, but the Supreme Court said there's no federal common law. There needs to be a civil cause of action basically by the legislature, and Congress has not enacted one. And so there's a very slight, tiny remedy that the Supreme Court enacted in a case called Bivens, going back 50 years now, but that has been cut back basically to the point of non-existence. So there's no civil suit against officers for constitutional violations. There is a theoretical exclusionary rule if criminal prosecution if a criminal prosecution is brought, but it's incredibly narrow. So it's only for egregious violations of the Fourth Amendment. Circuits disagree as to what egregious means. Some circuits, including the Ninth Circuit, say it's kind of like a qualified immunity standard. It has to be like a really blatant violation. Other courts take an even narrower view than that. But there's not much prospect of suppression of the evidence in a case. It's possible, but it's not that broad of a theory. Can't sue the government because of sovereign immunity. And then finally, relevant to us, injunction. So an injunction is a court order not to do something, where the court says you're not allowed to do the following things, typically the following things that I have found to be unlawful. And the role of an injunction would be to say, violate the injunction, you can be held in contempt. Whereas if you violate the underlying law, it's whatever those remedies are, which in the case of we saw in this slide, there's not a lot of remedies. The Supreme Court sharply limited the availability of injunctions in the Fourth Amendment setting in a case called City of LA versus Lyons. They said that in order to get an injunction against even a blatantly illegal government practice, you need to show that there's a real and immediate threat of it happening to you. So that thing that happened to you before, in Lyons, I believe it was a chokehold, you have to have a real and immediate threat that that same thing is going to happen to you, the plaintiff, before an injunction can be issued, which makes injunctions really, really rare in the Fourth Amendment setting. The picture I have drawn is one where there aren't a lot of rights and there's even less in the way of remedies, all of which is relevant to the injunction that was entered in this case. So this is the case, we have massive scale immigration enforcement, and according to the record in the case, lots of aggressive enforcement of the immigration laws, going up to people, seizing them, asking them questions. There's a lot going on in these cases beyond detention, but what the district court judge does is enter an injunction. Here's the language of the injunction. The defendants, that is the government, may not rely solely on the factors below, alone or in combination, to form reasonable suspicion for a detentive stop, except as permitted by law. And then there are the four factors: race or ethnicity, apparent race or ethnicity, speaking Spanish or speaking English with an accent, presence at a particular location, and then there are the examples, or the type of work one does. And so the question was whether this injunction stands, and the Supreme Court lifted this injunction. I don't know if I should keep talking and sort of offer. Okay, just a couple more thoughts. What stood out to me when the district court entered its injunction is, wait a minute, that's not a great fit with the claimed constitutional violation in three ways. I think there are three ways in which I look at that and I go, if I'm a law clerk to a judge, I'm going to say, Judge, we've got some problems with the way you've drafted this injunction. And here are, I think, three things at least to think about. First, the prohibition is on what the government relies on. To me, that sounds like a subjective consideration. You can't rely on that. Means like when you are planning your stop, you can't make that be the thing you're thinking is suspicious. The Fourth Amendment test, though, is not what an officer relies upon. It's what is objectively the evidence. So that first, at the front end, what we have here is sort of, the court is not actually describing what is the unconstitutional thing and saying, don't do that. This is sort of a prophylactic sort of effort to try to figure out what things are related to the constitutional violations and prohibit that. And so relying on certain things doesn't mean that those things, that an officer who relies on them violated the Fourth Amendment. Those are sort of considerations that the judge says are impermissible. So that's the one part, the reliance test. Second part of this, what exactly does this standard mean? So an officer is allowed to engage in a consensual encounter, and an officer is allowed to make an arrest. And there's nothing in this injunction that changes that. What the one thing that's being regulated is this intermediate step of reasonable suspicion. So even under this injunction, it should be legal to have all of these enforcement actions as long as they just approach people and don't say, stay here, until after they've spoken to them. Now, if somebody runs away, that may actually cause sufficient suspicion in order to detain them, and this injunction would not cover that because that would be an additional factor. The other part of the language here that's kind of odd is it's solely those factors. And so it's not totally clear to me exactly how this regulates what immigration agents do. If you're an immigration agent and you read that, are you allowed to make consensual stops, consensual encounters? Yes, those are fine. You're allowed to make arrests, but when you make a detention, an intermediate stop, you have to find some factor beyond those four that you're relying on. It's not obvious to me what that's doing. In fact, there's a way of reading this to mean sort of nothing. And so there's two problems. One, the Ninth Circuit below picked up on. There's that phrase, except as permitted by law. You're not allowed to do these things except to the extent that they're lawful. Well, what determines what's lawful? Well, that's the Fourth Amendment. So how do you know if you're following that? Because if it is lawful, then it's permitted by law and not covered by the injunction. So there's this question of like, what exactly does this change? We know what the trial judge was trying to do, which was to stop these practices that were that the plaintiffs were coming into court saying are occurring. It's just not obvious to me that that language actually did that. And then the last thing that makes it sort of odd in its language is that term solely. The government can't do this intermediate stop solely based on those factors, but there will always be additional facts the government relies on. So what are those? I mean, just to pick some of them from prior cases, the time of day. They're presumably not engaging in these enforcement actions at 3 a.m., right? It's during, the ones at least that were alleged, is sort of like the day labor pickup site, agricultural site, so it's sort of 9 to 5 kind of stuff. Okay, well then one of the government could say, well, we're relying on the additional factor of time of day or what the person's wearing. Are they wearing a suit versus are they wearing casual clothes or whatever it might be? In theory, that raises an interpretive question of what the injunction means. Of if the test is solely, I hate it whenever legislatures use the word solely. It's always law professors hate that. So does that mean like if there's just a teeny little grain of sand of additional reason, it's not, because it's not solely anymore, it's primarily, but it's not solely. Is that outside of the injunction? Just looking at that injunction, that's not actually a great effort to try to stop the practice. So that immediately, just from a Fourth Amendment standpoint, I thought, I suspect the Supreme Court is not going to want this to continue just because that is just not a great effort to articulate that which the Fourth Amendment prohibits. The additional problem, I think, in the case is in the prior slide, I talked about how the City of LA versus Lyons case required that an individual plaintiff say, here's this unconstitutional thing, and there's a real and immediate threat of this thing happening to me in the future. And there wasn't great evidence of that, in part because none of these cases were adjudicated as to like, did the government have reasonable suspicion in these cases? Instead, it was, here are circumstances where, as described by a person, they didn't think there was cause to stop them, but whether that would amount to cause based on what the government knew, we didn't have, there wasn't a trial. There were no particular facts. It's like, here's an ongoing practice. And I understand why, I get it from the standpoint of the trial judge saying, I think there are a lot of constitutional violations occurring at scale. I'm going to try to stop them. But the limits from Lyons on injunctions sort of make it really hard to do that. And I can understand why the district judge would have said the other remedies are terrible. Here's at least a remedy. But it's not obvious to me that the state of the injunction law actually allows judges to do this. And the effort to try to craft what it is that's unconstitutional, I think, was not as well done as it should have been. I think you can sympathetically read Justice Kavanaugh's concurring opinion as basically identifying those two flaws. He says City of LA versus Lyons is not satisfied, and then also there are a lot of circumstances where there would be constitutional stops despite this, and therefore that's why he's overturning the injunction. There's a lot going on in the use of the shadow docket, and I'm not a fan of the use of the emergency interim shadow docket, whatever you call it. Yeah, so there's a lot going on in terms of how to weigh the equities, and that's not my issue. I think Duncan may be talking about that question. And so I'm not saying what the court did was sort of the right thing to do. I'm saying that when the injunction came out, I looked at that and I said, I don't think a district judge has the power to do that, and it's not a very careful effort to try to do what the judge was trying to do. And so I was not hugely surprised when the Supreme Court lifted the injunction and allowed this to go on without the injunction. So not to approve the current state of the law, either of injunctions or of Fourth Amendment law or of remedies. I have a lot of criticisms of a bunch of these parts we can talk about. But the state of the law, in my view, I was not surprised when the Supreme Court intervened. And I didn't think what the trial judge did probably was lawful based on the law at the time. With that, pass it on.
Fantastic, Orin. I'm going to begin similar to Orin with some context, and I'm going to focus on a different analytical lens, what Orin just ended with, which is talking about the shadow docket and how Vasquez Perdomo fits into the shadow docket at the court. And then I'm going to mount a vigorous defense of the district court injunction in this case, which I think is both justifiable as a matter of the law before the court, but also important in larger context as a bulwark against the authoritarianism we're seeing emanating from the White House. So I'm going to begin with the shadow docket. The Supreme Court has always had emergency procedures to deal with petitions that come before it outside of the normal merits briefing. A merits briefing is the type of standard case we imagine the Supreme Court hears, where there's briefing, there's argument, you go through the normal deliberative process. But over the past 20 years, the shadow docket has changed radically in its scope and its importance. The Obama administration filed 8 emergency petitions to the Supreme Court on the shadow docket. The Bush administration, over 8 years before that, filed 8. The change really begins in Trump 1.0, where the Solicitor General over 4 years, so half the time, files 41 applications on the shadow docket for relief to the Supreme Court. And the Supreme Court grants relief to the Trump administration in 28 to 32 of those cases. So institutionally, Solicitor General is changing how they go to the court on the shadow docket. Also, conservative public interest groups notice this trend and begin going to the court in much higher numbers to try to get relief before the court. Why are parties doing this? The consolidation of conservative power on the court changes the incentives for litigants before it. In 2018, Trump appoints Justice Kavanaugh to the court, replacing Justice Kennedy. Justice Kennedy overall is a conservative jurist, but someone who's not especially doctrinaire and not socialized in the same type of milieu that Justice Kavanaugh comes up from. More consequentially is 2020 when President Trump appoints Barrett to the court, replacing Justice Ginsburg, and that really moves the court to the right. And a result of that is that you see the shadow docket majorly taking off as soon as Barrett joins the court. And when Barrett joins the court, the institution begins using the shadow docket to change the law in really substantive ways. An illustrative example would actually be one that came out of Santa Clara County, a case called Tandon versus Newsom, which the Supreme Court uses the shadow docket to change the governing standard underlying free exercise religious freedom claims, along with another case from Southern California called South Bay Pentecostal versus Newsom. So we see the shadow docket changing in both the number of cases being decided on it and the importance of the cases deciding on that. And the final thing I'll say about the shadow docket before talking about this case and how it relates to the shadow docket is that the court is not using the shadow docket the same way in every case. Sometimes, like in the Tandon case I talked about, there's a new legal rule being created in free exercise. Sometimes there's not a consistent legal rule. It's being outsourced to the lower courts to try to come up with different standards, and you see different rules based on where you are over the country based on the Supreme Court shadow docket order. So a major example would be the right to abortion. We typically assume the Supreme Court overturned Roe and Casey, which protected a constitutional right to abortion, in the Dobbs decision in May 2022. That's technically right as a matter of law, but if you're a woman living in Texas, the Supreme Court on the shadow docket eliminates your right to abortion earlier than Dobbs in a shadow docket order called Jackson versus Whole Women's Health, where the Supreme Court intervenes, reinstates a Texas law called SB 8, critics refer to it as the bounty hunter law, that immediately shuts down abortion access in Texas. So if you're a woman in Texas, the relevant question is not Dobbs, it's that shadow docket order. But if you're a woman in Oklahoma, what matters is Dobbs, not the shadow docket order. So I say that as general context. Let's begin with Trump 2.0. In the first administration, as I said, there were 41 petitions to the Supreme Court. The Trump administration, in just the 10 months of the current presidency, has gone to the Supreme Court 28 times. It's received the relief it sought in either 23 or 24 of those cases, depending on how you want that. So the court has consolidated it and is very deferential to President Trump and is using the shadow docket power in a way that doesn't necessarily cohere with the priors of the conservative legal movement. We've seen time and time again, not in this case, but conservative judges issue injunctions against the Trump administration, especially those as appointees of Ronald Reagan, and those orders being overturned by the Supreme Court. This case follows the 23 paradigm I talked about earlier. A district court entered an injunction against the Trump administration. The Trump administration appealed to the Ninth Circuit, the appellate court that covers California. A 3-judge panel unanimously on the Ninth Circuit validated that injunction. The Trump administration, its Solicitor General Sauer, goes to the Supreme Court, demands emergency intervention, and that's how this case reaches the court, and that's where we get the docket there. The shadow docket order, Orin is right, there is no substance to it from the court as a whole, so we're left with one sentence that is ambiguous. We also have Justice Kavanaugh's concurrence. I think through our discussion, I'll maybe mention Justice Kavanaugh's concurrence because I think there are reasons why to think the other conservative justices find his reasoning convincing, but we're left with confusion. But in confusion, I think there can be new legal rules. So now I want to turn to the district court injunction in this case, which is what the Supreme Court intervened to stay. I want to make 3 core points about this injunction. The first is to focus on how I view it as actually a narrow approach to this problem. It's not a generalized obey the law injunction, which would raise problems, and we'll talk about Lyons because that's a central issue in this case. The second is I want to contrast how the district court dealt with evidence as compared to the Supreme Court, and that goes to Orin's points about what is the district court relying on, because I view that particular question of what is going into the analysis differently. And the third is I want to talk about why the district court injunction is important, not just in this case, but in the context of what Trump administration is doing overall. So let's talk about the word Orin focuses on, and I think is also critically important to understanding this injunction, the word solely. Defendants cannot solely rely on these 4 factors in combination or alone. And again, those 4 factors are apparent ethnicity, speaking Spanish or speaking English with an accent, the presence at certain locations like Home Depots, or working certain types of jobs. The role of the word solely is recognizing that the administration is not prohibited exclusively from engaging in race or other considerations, but they have to point to something more there. They're raising the threshold the government has to go to, and the district court isn't in an epistemic position to predict exactly what the government could marshal or not marshal, but it's saying we're setting a minimum floor of what the Trump administration must do. You must do more than what you've done in these types of cases. And I think that's an appropriate use of the injunctive power that is consistent with Lyons, but it's setting a baseline, a minimum we should expect from the Trump administration, particularly when the Trump administration and its immigration enforcement has been acting in ways that are deeply disturbing. That brings us to the second point, the role of evidence before the court. There are 3 different groups of plaintiffs in this case. You have a set of Latinos who are undocumented, Latinos who are citizens, and then organizational groups that represent a mix of both of those categories. There are 21 sworn injunctions in this case that come from those 3 groups of people, and they document really alarming allegations. The named plaintiff in this case, an individual named Vasquez Perdomo, he's a day laborer, he's working, he's having coffee at a bus stop outside a donut shop. 4 ICE vans show up, they don't identify who they are, they grab him, they seize him, they take him away from where he was. He was undocumented, but when they took him, they don't give him an opportunity to explain where he is, they don't explain what they're doing. They're armed. This is a really serious violation, even of the rights of undocumented people. They're US citizens in this case who are removed from their workplaces. That's a declaration of Gavidia. He's working at a car wash, and it's the Viramontes declaration. Working at a car wash, removed from his workplace. He tells the agents, I'm an American citizen, I'm an American citizen. They refuse to accept that as an answer and only return him 20 minutes later. So I bring those 2 declarations to point out the fact that we're talking about extraordinarily aggressive tactics, ones that are, I would argue, outside the normal understanding of what we permit law enforcement to do. I would say they're unprecedented. You have to go back to Operation Wetback to see a scale of operations similar to the Trump administration. But even Operation Wetback, and we can talk about why, is very different from what the Trump administration is doing right now. And the district court is going through those declarations really painstakingly. Justice Kavanaugh in his concurrence doesn't cite to any of the declarations. So Justice Sotomayor in her dissent goes through 29 citations of it. Justice Kavanaugh doesn't invoke it at all. So you see a difference where you have the district court very closely parsing this evidence, the Ninth Circuit parsing the evidence, the district court and the Ninth Circuit together, you have 113 pages of opinions. It gets to the Supreme Court. We have no explanation from the court what they're doing. Justice Kavanaugh writes a concurrence justifying the action with no citation to the actual record, and a lot of claims that actually don't have citation, including statistical ones that are contested, and then Sotomayor basing on the record. So when we're talking about who's relying on evidence, I would say the courts that are trying to stop the Trump administration are relying on evidence. It's the government that's not. The final point I want to make is contextualize this case outside the immigration context and put it in the general frame of the Trump administration vis-a-vis the Supreme Court. The Trump administration has had an extraordinary winning streak before the Supreme Court, and I worry this type of injunction is an example of a pattern that will continue to embolden them. there's always a disjuncture between the legal rules the court articulates and how those rules are felt on the ground. Immigration law is one of those. The same day the court issues the shadow docket order in Vasquez Perdomo, the Trump administration announces a new immigration Operation Chicago, Operation Midway Blitz. And what we've seen from Midway Blitz is really disturbing in ways that are much more extreme than in Los Angeles. The largest example would be the ICE agents using a helicopter going into an apartment building on the south side of Chicago in the middle of the night, waking people up, putting children in zip ties, putting citizens in zip ties, putting black people in one area, Latino-looking people in another, with no explanation there. Tricia McLaughlin, the ICE spokesman, was asked, you can't do this, what's the basis of it? And she pointed to the Supreme Court shadow docket order here. So I bring that up as an example that we have to understand what the Supreme Court's doing in context of this very dangerous administration that's looking for legal authority for things that are clearly unlawful. At the district court, I don't think the injunction was necessarily perfect, but it was an effort to say to this administration, stop, you are doing things that are wrong, that we cannot tolerate in our constitutional culture. And by overturning it, the Supreme Court is emboldening abuses that are continuing in the immigration context, but of course are not limited to the immigration context. We see the shadow docket playing out in a range of areas. So there's a lot to work with there. I'll let you take where you want to start.
Yeah, so I think there are a lot of distinct issues here, which I think we really need to break down. So one, as a matter of policy, what do we make of the Trump administration's enforcement immigration? Two, as a matter of law, what do we make of the ways that the Trump administration is going about its policy? Three, what do we make of the injunction in this case? And there are three distinct questions. I mean, in a lot of ways, actually, the injunction that was entered in this case that's lifted by the Supreme Court, it's particularly ill-suited to address the concerns that Duncan has. Because, I mean, maybe the trial judge hadn't sort of thought through this fully, but if you take the biggest problem to begin, I think this is one of the biggest problems, sort of the government coming onto the street and grabbing people and taking them to some sort of immigration detention facility, that is outside the scope of the injunction. Because that's temporary detention. You can't do that based on mere reasonable suspicion. That's an arrest under Dunaway versus New York, a 1979 Supreme Court case. That requires probable cause. That cannot be justified as a temporary detention. And yet, the way the injunction was written, it only covers detentions. So, actually ironically, the injunction that was written was only addressed at a minimal step without addressing the bigger issues that are of broader concern. Now, to some extent, you could take the view, well, try to do something even if it's not sort of perfect. Something's better than nothing. But just from the standpoint of, did the district judge identify the illegal acts and then craft an injunction saying you can't do the illegal acts? I think actually the injunction is not addressed towards the things that we're most concerned about. And this also came up in the shadow docket opinions. Justice Sotomayor pointed to the concerns of excessive force, for which there are no civil remedies under the complete absence of a Bivens remedy these days, or not complete absence, but 99.9% absence. The injunction didn't address excessive force. Now, perhaps the judge was thinking that if you don't allow detentions, temporary detentions, maybe the temporary detentions are what will lead to excessive force. That's possible. But if the problem was excessive force, the injunction should have been addressed to excessive force. And I think this crafting injunctions in Fourth Amendment cases is disfavored, and Lyons basically makes them extremely rare, in part because of the difficulty of articulating exactly what is this unconstitutional thing that the government shouldn't do beyond just restating Fourth Amendment law. Don't arrest people without probable cause is the legal standard. And an injunction saying don't arrest people without probable cause just amounts to follow the law. You don't need, the Fourth Amendment should be the injunction that does that. You don't need an injunction for that. The purpose of creating an injunction would be to create effectively a civil remedy that the Supreme Court has said should not be there, which is it effectively creates like a Bivens-like remedy. You say, hey, they arrested me without probable cause. It's not that they violated the Fourth Amendment. The problem is that they violated the injunction. And then that leads to a remedy where you wouldn't have a remedy without the injunction. But the Supreme Court's answer is we don't think there should be a remedy in these circumstances, going back to these cases, cutting back on Bivens. So I think there's a lot to criticize here, but in the state of the law before this ruling is certainly key to that. But at the same time, if we're going to focus on what the Supreme Court actually did in this one case, in lifting this one injunction, there's symbolic aspects to it, there's media aspects to it, and obviously this case got a lot of attention. That's why you're here. But the actual injunction itself, I think, had legal problems, and I wasn't hugely surprised when the Supreme Court lifted the injunction.
Great. Well, there's a lot to work with there, and we agree in a few domains. I begin that if we concede there are legal problems with the injunction, which I'm not going to do overall, I will say there are aspects that could be better. I think the broader legal problems are with the Trump administration's actions and the Supreme Court. So the standard we're dealing with is not whether the district court had a perfect injunction or not, but whether the Supreme Court should intervene at this posture. When you're issuing a stay of an injunction, you look at what's called the Nick and V. Holder factors, and that is a different question about whether this injunction is perfect or not, but whether it meets certain thresholds that we tolerate there. Historically, issuing a stay of an injunction has been understood to be an extraordinary step, an extraordinary act. There's a part of Justice Sotomayor's dissent where she does reference that case law. I think it's a fair question whether it is still an extraordinary step because we've seen the Supreme Court in the past 10 months intervene so frequently to undermine injunctions issued against the Trump administration. But if you go back to January 20th of this year, that was the state of the law there. So again, that is to say that the injunction itself is an extraordinary remedy, and we have to be rigorous in what we demand from it too. On the same hand, we have to be demanding of the court to justify this intervention of the scope. I want to respond to 3 points that were made by Orin. And again, I'm going to criticize Kavanaugh throughout of it. We wish you were the Kennedy clerk who had Kavanaugh's seat on the court. It would be so much better. The first is the policy versus law distinction. The central issue in this case is is the district court just disagreeing with the policy aspects of the Trump administration? Are there constitutional violations there? To the degree I think policy is entering this case, I see it in the Kavanaugh concurrence, where he's sharing his views subtly on the Biden enforcement operations. He has irrelevant extraneous information there that has nothing to do with the case beforehand. He seems to be justifying the actions there based on his policy support for what the Trump administration is doing. And again, the difference in form that the dissent Sotomayor issues and Kavanaugh's concurrence take is striking. She's citing to the record 29 times. He cites to the record 0 times. So he's reasoning, I would say, from policy considerations, where Sotomayor at least is trying to make the form craft of law. On the question of whether the injunction is ill-suited to this particular problem here, I think district courts are struggling because it's rare to have a situation in which you have a government in the executive that is trying to break the law in an explicit way. Stephen Miller, whom Operation at Large, this operation in LA is derived from, has said in context that he thinks we should be racially profiling in a blanket way that's inconsistent with case law. And so when you have an executive that's acting in a way that's outside our constitutional norms, it puts district courts in a very difficult position because to craft injunctions, they're relying on a set of tools that are premised on good faith. They're premised on this idea, the presumption of regularity, that when the government goes to federal courts, they're presenting evidence faithfully. And that's not the case we're seeing with this Trump administration, both in the motivations of it to expressly violate the law, and also in their engagement with district courts, where they're misleading district courts, they're stonewalling district courts, they're misrepresenting case law in their applications, they're citing cases, in some cases that haven't existed, or stating cases that don't stand for the principles they're stating for. So when you're dealing with an administration that is acting this lawlessly, it puts district courts in a very difficult situation. Another aspect that's hard for the district court and actually the civil rights litigants in this case is that ICE has made it difficult for lawyers to meet with clients at the federal detention facility. So I mentioned the named plaintiff Vasquez Perdomo, who's taken to the, it's called B18 facility. It's in the basement of the federal building in Los Angeles. In that facility, ICE has made it extraordinarily hard to get information out about what's bringing it. And so the plaintiffs wanted to bring additional claims beyond the Fourth Amendment one, but there were not enough evidence. They struggled to get information from the people inside that facility. And that's a policy from ICE. So we're dealing with civil rights litigants and litigators who are struggling in this unique context the Trump administration is creating around immigration enforcement. And I would say I do think something is better than nothing, that I hear you and there are concerns in the injunction. But those concerns were, frankly, the best the district court to do. I would if you could point to how the district court could have structured it differently in a specific way working on this timeline. And I would say something is better than nothing, in part because the Trump administration has vigorously contested this injunction so much. So if the district court's injunction were impotent to deal with the constitutional abuses of the Trump administration, we would expect the Trump administration not to fight it so vigorously. But they seem to be understanding it as a serious impediment on what they want to do in immigration enforcement. And I think that's significant in their actions. The final point on Lyons, which is this Article 3 standing case, I would make 2 points. The first is talking about how litigants could show there's not a Lyons problem in this case. And the second is to contextualize Lyons, because I think it's an infamous case in standing doctrine, particularly in Article 3 context in the court, is really a mess right now. But in terms of Lyons, there was a specific factual finding by the district court in this case that the type of abuses that were inflicted on the plaintiffs were likely to reoccur. There wasn't that finding in Lyons at the district court level. The district court is entering that type of finding to avoid a Lyons problem later on. Lyons is dealing with the chokehold policy in the Los Angeles Police Department. There was a 24-year-old black man who was taken out of a car, put in a chokehold when the LAPD had a policy of using chokeholds proactively. There was a factual predicate to the application of the chokehold to him that's different from this type of case. That individual who suffered the chokehold was doing a traffic violation. Here, the harm is being Latino. That's one of the core factors the district court injunction is dealing with. And so there's a step that was removed from where you get to the Lyons there. And second, I would point to evidence in the record that there have been recurrent stops to individuals. There's one of the named plaintiffs, someone named JME, who has been stopped twice by ICE through Operation at Large, and we're looking at that 1 month period. So if you're trying to show that this is likely recurrent, ICE is saying we target certain locations, and you have one of your named plaintiffs who can say specifically, ICE has gone after me twice and I've experienced these types of indignities twice, it seems to me that's likely to be recurrent and likely to be specific. So that is how you could respond as a lawyer to the Lyons. Taking a step back from Lyons, I think Lyons is a terrible precedent. I agree with you, the state of the law in standing is wrong. And it was a 5-4 decision when it was decided. It remains very controversial. There's been scholarship on how federal appeals courts are trying to narrow Lyons in ways that avoid Supreme Court scrutiny. So I would just say it's not like Lyons is this perfect precedent that everyone accepts as a baseline, but I concede it is something that we have to deal with in this case. Beyond that, though, the court's approach to standing has been best described as incoherent, which is why I don't want to put too much emphasis on standing. In 2023, the Supreme Court finds standing in 303 Creative in this pre-enforcement challenge case about a gay artist who has no evidence Colorado is going to go after her. They were able to find standing in the Missouri versus Biden case involving student loans, in which there's no harm there. So I would just say, analytically, I don't think standing is doing that much here or in the court's jurisprudence generally.
Great. Let me just offer 2 quick thoughts, and then maybe we'll open it up for questions. So first, I agree with Duncan's concerns about the use of the shadow emergency interim docket, whatever you call it. We're in that stage, incidentally, it has 3 names. So you have to use all 3 of them to make sure everybody knows what you're talking about. But the interim docket, I think, is really problematic because when the court has spoken on an issue, it will be interpreted as a final ruling, and whether the justices see it as a final ruling is itself something that remains to be seen. Sometimes they seem to say it's not. Sometimes they seem to treat it like it is. But if you're a lower court judge, you're going to treat it as a final ruling. When there's no explanation of what's going on, you don't know what to do. And for the Supreme Court to kind of step in just a few cases nationwide and sort of pick those as the cases that it intervenes on is, I think, really problematic because the court really can't decide things without a lot of briefing. I mean, Supreme Court cases are really hard, and the cases where the court has to do briefing really quickly are the worst opinions, just reliably. If you look at a Supreme Court case and it was decided really rapidly for some reason, think like, Bush versus Gore, I think, is one example. Even people that like the result say, oh yeah, those weren't very successful opinions, because trying to write a legal opinion in a day or two is just, it's not going to be successful. And I think this should be an issue that is bipartisan, although the political valence of it maybe has reversed. I was a law clerk 20 years ago, and at the time, the use of the shadow docket was all about capital cases. And then it was flipped. Then the conservatives said, why are we stepping in and doing this one-off individual case justice? We have standards for when we intervene, and we should only intervene when it's a case of national importance. And those on the other side, on the more liberal side, we're saying this is a capital case. Death is different. We need to monitor. Basically, each execution in the United States, there were maybe 50 or 60, depending on the year, would get all of the justices reviewing each case that happened before a capital sentence was carried out. And so in a lot of ways, the political valence has flipped, and perhaps unsurprisingly, the attitudes towards use of the interim docket have flipped as well. And so I share, though, that sense that it's problematic and the court should not be intervening nearly as often as it does, in my view. And I'll just add another kind of bipartisan point here. There should be a civil action for a violation of constitutional rights. In the state level, if a state officer violates your rights, there's such an action under Section 1983. And there's a qualified immunity defense, but at least there's a civil action. In the federal system, there's no Section 1983 against the federal agents. There should be some sort of cause of action. In fact, I think everybody kind of assumes there's a cause of action. It's not until you get to a real case and people go, oh, wait a minute, there's no cause of action in this case? That's wild. And I think that tripped up Justice Kavanaugh, too, in his concurring opinion, where he talks about if somebody is subject to excessive force, they can file a civil action. No, they can't. Bivens is dead.
Because of opinions he's joined, too.
And so there needs to be that cause of action, and it's unfortunate that we've seen the Supreme Court cut back on this cause of action to the point where it basically doesn't exist. And the political system has unfortunately not yet realized this cause of action we all assume is there is not there, and it needs to enact such a cause of action by statute. It's entirely possible that in the next 5 years or so, the Supreme Court will, rip the Band-Aid off, whatever analogy you want to use, and just say, we completely end this cause of action. I would like there to be that cause of action, but maybe the Supreme Court just outwardly saying this is done, this is up to Congress, might inspire congressional action. Although even when it comes to Congress, you can't assume they will step in, or else they would have a long time ago. So we need that cause of action, whether the courts create it or whether Congress creates it. If a government agent violates your constitutional rights, there has to be a remedy, or else we see what we may be seeing, which is violations without any remedy at all.
Questions, comments? Yes?
You can line up at these microphones if you'd like to ask your questions so everyone can hear, if that's okay. And I'll run and turn the other one on.
So one thing Justice Sotomayor talked about a lot in her dissent is about the particularity requirement to reasonable suspicion, how it has to be individualized to the person. And so I'm just curious to get your guys' thoughts on how that factors into how you think about the injunction, how that requirement factors into how we should think about the injunction here.
Great, I'm willing to start. Reasonable suspicion needs to be particular, it needs to be articulable, and it needs to be based on an individual. The factors in the district court's injunction here, again, apparent race or ethnicity, speaking Spanish or speaking English with an accent, presence at a particular location, or doing certain types of jobs, don't on themselves give the government enough to have a particular suspicion. That's true everywhere, but it's especially true in the Central District of California. Both the Ninth Circuit and the Supreme Court in the dissent of Justice Sotomayor point to statistics that 47.3% of the population that's being considered in the Central District is Hispanic or Latino. So on that first factor of apparent ethnicity, you're gonna get a lot of people in that bucket. If you go down the other factors, if you look at the number of Spanish speakers at home in Los Angeles County, it's around 37%. Again, that's in the record and it's part of the Ninth Circuit and the Supreme Court dissent by Justice Sotomayor. And then 55% of the county is speaking an English non-language at home. So the district court's factors, I think, correspond to this reality, particularly the demographic reality of where we are, that without this injunction, the immigration rates are going to be too sweeping and they're going to get too many innocent people who aren't. And the final thing I would say on that is there's a reason that in this case, 2 of the named plaintiffs are US citizens who've been caught up in it. And that shows that the operation is far too over-inclusive in who's getting caught up in it.
Yeah, so I disagree with Justice Sotomayor in the sense that I don't think these issues are what is particularized. I mean, visually observing a particular person at a particular place, that's particular, and that is like, it is about that person. I think the real argument there is about that is not cause, or that is not suspicious enough. So there's whether something is particularized to a person, and then there's how much suspicion that adds to that person's, whether that person committed a crime or in the immigration setting is here unlawfully. I think of it as being a amount of cause question rather than a particular question. And Brignone-Ponce said it was relevant. What does relevance mean? Like, relevance could be anything. It's a slight relevant, just the race question alone. It's hard to know if you imagine sort of how this would normally be litigated. Take this outside of the quirky setting of the interim docket. We would have individual stops, individual statements made that could be subject to suppression in a criminal court. We would have individualized determinations of suspicion. We would have appeals based on appellate court evaluations. Is this enough to have reasonable suspicion? Is that enough to have reasonable suspicion? We would have lots of cases, and the courts could sort of weigh in on this based on evidence at a motion to suppress. And what's particularly challenging in this setting is, although we have statements and affidavits, we don't have a trial. We don't have hearings as to what's the likelihood of various things being the case that would allow courts to, in the ordinary course, over time, sort of what the Supreme Court referred to this as something like percolating, like have lots and lots of judges weigh in on what is suspicious, have lots of hearings, have lots of experts weigh in, and then eventually maybe the Supreme Court could take a view of this. You can't get any of these decisions or any judgments of this, I think, from the interim docket context. Now, what I think the majority of justices would say is, yeah, that's why we're not issuing an opinion. We're not resolving any of this. But it may be perceived as being resolved in some ways. And I think Justice Kavanaugh kind of, he dealt with this problem by sort of imagining a case, it's sort of, you have this problem of, let's say there's 100 stops. There's some number of stops that are going to violate the Fourth Amendment. We don't know what that number is. And so, the difference between Justice Kavanaugh's approach and Justice Sotomayor's approach is Justice Kavanaugh, from what I sort of take him to be doing, is he's saying, there's going to be some significant number of these where there is reasonable suspicion the Fourth Amendment wasn't violated. And Justice Sotomayor is saying, but there are going to be some cases, and I'm going to sort of, here's my situation going to be where I think there isn't reasonable suspicion. Neither of these judges are in a position to sort of identify a set of facts. There's no facts in the case yet. It's an injunction covering a broad category where the nature of this saying, like, here's the category of cases. You basically need to resolve how the Fourth Amendment applies to like an infinite set of facts, which I don't know how you do that. So I'm a fan of the case-by-case litigation, have everybody weigh in, have a motion to suppress, have both sides offer their witnesses, and get litigation case by case. I just think this whole trying to reach decisions or even identify broad principles of law that are in any way new on the interim docket is just not a context in which they can really say new things because they don't have the basis for it, in my view.
Since we're running a little short on time, does everybody feel good about asking all the questions now, and then you guys can sort of take them triaged?
Great.
Great, thank you.
Thank you for having this event. I just had one question about, you kind of all touched on it, but about how the district court grappled with Brignone-Ponce, and like, was the use of the word solely a way to get around the fact that race could be considered as a relevant factor? And I just had a question about, you talked about how the injunction wasn't really well crafted to deal with a lot of the concerns we have about immigration enforcement, and I just had a doctrinal question about the line between detention for immigration enforcement, which is governed by Brignoni Ponce, as you said, but then like an actual arrest, and what kind of the line is between that. Thank you.
My question was about, you mentioned Bivens, you mentioned the restrictions on injunctions in this kind of case. Is it possible at all to get a speedy remedy in this kind of thing, or I guess speedy response to these kinds of actions that we're seeing, or is it more of the Fourth Amendment necessitates a case-by-case evaluation?
Thank you for giving the talk. I guess my main question is about, well, you focused a lot on standing and Lyons, I think, in both your presentations. And I'm more curious about the injunction side, because I'm thinking about the effect of CASA back from the summer, and possibly, what would happen if, I guess, Professor Kerr, if the district court issued an injunction with teeth that had maybe an actual effect, do you think that this could be challenged using CASA by saying that it reaches too many people? Because it seems like the injunction in form essentially directs the police to act in a certain way, which probably goes against CASA's teaching that you can only touch named parties or parties before the court. So I'm curious if that's a point of worry for you.
You guys have sort of indirectly touched on this a little bit, but I was wondering if you could reflect on the difference in the number of literal facts cited between the dissent and concurrence. Kavanaugh has a bunch of statements that have no footnotes, typically brief when he talks about stops of citizens, other things like that. The dissent, meanwhile, has lots of cites to, declarations, to be fair, but, the record. And then one other thing, just how it seems like ICE is using Kavanaugh's concurrence as a justification to make basically suspicionless stops, or what seem to be suspicionless stops.
Hi. Chief Justice Roberts famously said the way to stop discriminating based on race is to stop discriminating based on race. So my question is, why would the Supreme Court allow race at all in forming reasonable suspicion when they won't allow it in college admissions?
Absolutely. I'll just start with that where, because I feel it's something resonant in our public discourse. In Students for Fair Admissions, there's that famous quote about the way to stop discriminating on the basis of race. Also, in the recent affirmative action cases, you see that principle being articulated there. I think the formalist answer would be that the Fourth Amendment is treated differently than equal protection under the law, and so those are viewed differently. I think an area where we may disagree about the degree to which this is an equal protection case, it's not one of the claims being brought there, and there are a variety of technical reasons why litigators aren't bringing it there, but I view it as pervading the entire case. Justice Sotomayor, in her opinion, is talking about equal citizenship, so that's in the register of equal protection, even though she's not making a full equal protection argument. And the District Court and the Ninth Circuit are also in subtle ways talking about equal citizenship too. So I think your point is taken that there is some contradiction there. I think a sympathetic way to think about it is that these are two different doctrines of law, but I think if you are seduced by this colorblind vision of constitutionalism, which the court's conservative justices are when it comes to dealing with remedying invidious discrimination, at a minimum you would want it to apply across the board to examples where you're using race to target people on the basis of it. So I think it's a really valid point, and I hope litigators continue to bring this forward because there's an analytical tension between those that's very serious.
So there's a whole lot going on in the questions. I want to run through some of them pretty quickly. First, on the use of solely in the injunction, I do assume that the trial judge read Brignoni Ponce said, oh, solely race is illegitimate, and therefore I will have the injunction be you can't solely rely on these different things. I think that's not quite a good fit because the difference is in Brignoni Ponce, it was this is what we did. We did only this. We relied solely on this fact. But if you announce the rule is you just have to declare something else in a future case, the government will have lots of future things to rely on. They're never going to have another case where you're right, we only relied on these things. And then you have to have a trial judge say which things that were small that were relied on are too small to count within the solely test. Again, that solely language is hard to use as the basis of an injunction. I do think one of the, there was a question about universal injunctions. I do think that was a part that Justice Kavanaugh very carefully avoided going into. That was an argument that the Justice Department tried to make, not only that the injunction violated Lyons, but that it amounted to a universal injunction that could not be asserted. And I think basically Justice Kavanaugh was trying to just basically say, this is Lyons, this is Brignoni-Ponce, and we're done. We're not doing new things. The alternative would have been to say, we interpret the universal injunction case broadly to apply in this setting too, and totally understandably, you wouldn't want to add to it in that particular setting. In terms of citations to the record and whether that makes a difference, I don't think that makes a particular difference. There was no trial in this case. It's not like we have hearings below. It was declarations that were made, and the real question was the legal relevance of those declarations, not what were the declarations. So I tend to think that the key question was the legal conclusions and statements that were made, and more broadly, this is, I think, a problem with the shadow docket rulings. It's not a ruling, right? It's like a one line, we vacate the order, we're not telling you why. I think that's problematic regardless of the case, or at least that's something that should be done really sparingly. So, whatever Justice Kavanaugh did in terms of number of cites to the declarations made, I think the real issue is, should the Supreme Court be intervening in lower court cases with unexplained orders that may be construed broadly by lower courts, or at least are of uncertain relevance to lower courts. And that's something that is it's a dangerous authority that should be used really sparingly. And apart from this case, the Supreme Court has been doing this more broadly, and I think it's a problematic tool for them to use in the run of cases and has been for several years.
Just two quick follow-ups on that. On the question of the evidence before the court, I think this is a relevant area because the Supreme Court should reflect its role in an appellate posture. The district court in this case didn't have a full evidentiary hearing, so I agree with you on that, but there was one type of hearing, and if you look at the transcript of that hearing, the district court is pressing the government and the plaintiffs on this case on some of their factual assertions. We're also talking about 21 declarations that are sworn under penalty of perjury. When the government appeals to the Ninth Circuit and then petitions the Supreme Court for the review, the government is not objecting to the factual narration of this case, which is different from when I talked about earlier, the 28 other applications. You see the Trump SG in many of those cases objecting to the facts, but both before the Ninth Circuit and in its application to this court, they're not objecting to those facts. So I think we can treat these facts not as decided, but based on the government not fulsomely contesting them, and also the declarations being sworn, as the best we can do here. And ultimately, the district court as an institutional role is much closer to the facts, and so that's why when we talk about the Nick-Invest Holder factors, you want to have some deference if you're in an appellate posture towards those factual conclusions. On the Casa versus Trump point, I think the district court is thinking about this closely. However, the operation is limited to the Central District of California, and that's the jurisdiction there. They're not even asking for a universal injunction in this case. I think it's a challenge for litigants going forward that when the Trump administration is starting these operations across the board, some of these roving patrols are being sent from one place to another, how you come up with a systemic solution. But so far, civil litigators are coming up with approaches to that. But the district court is very much aware of Casa versus Trump, and you see that throughout the opinion there.
Thank you for your presentation. I have lots of questions, but I'll end with just this one. Given the nature of the court and the tremendous order, we vacate the order. How do you teach this to your students?
I don't teach this term, so I'll give it to him. I'm grateful for that.
Yeah, the law of the Fourth Amendment remains, and the problems of there being like no Bivens remedy and the exclusionary rule being narrow, that's a day-to-day reality of every courtroom in the United States and has been for a long time. So the law is the same state of the law regardless of what the court did with this one order. It may not be the best situation, but we go into the classroom with the law we have for purposes of teaching what the law is, and we criticize it and critique it and come up with our proposed reforms to have our normative views, but that's the same thing that law professors will always do.
On that note, will you join me in thanking our distinguished guests tonight, Duncan, Hosie, and Orin Kerr?
Thank you. That's good.
I hope you'll all join us here next week, same time, same place, for Professor Philip Zelikows' talk on presidential emergency powers, another very timely issue. Thank you.